49 Collins Road, Harlem, GA 30814. Email, petershank747 @gmail.com. Cell 706-597-6445. Home 706-556-8028. November 1, 2016. Subject: complaint timely filed by statutory provisions of applicable laws, including civil rights and due process by law. 2. Mr. Robert J. Barnhart, Director, Compliance and Control Division, Office of Federal Operations, Equal Employment Opportunity Commission, P.O. Box 77960, Washington, D.C. 20013-8960. Subject: regarding Peter Shanks v. Megan J. Brennan, Postmaster General, OFO Docket Number 0120161493, Agency Case Number 4G320-0051-16. Dear Mr. Barnhart, this complaint is timely by law and statute based on numerous allegations, law and procedural inconsistencies as factors to this discrimination claim of misconduct by a federal agency. The agency altered methods, created gimmicks that obstructed rights of timely filing. Review of all appeals and complaints filed appear to be untimely filed against the agency's unlawful termination decision. Plaintiff was employed as a mail carrier. Plaintiff has attached factual documented evidence supporting alleged misconduct. Factual and circumstantial explanations concerning problems filing appeals of review, conflicts of law and obstructions of justice pursuing justice and relief. Corruption is believed to be a major factor in plaintiff's termination due to grievance arbitration, altered method of process, required USPS processing checkpoints, procedural and administrative reviews, as well as the Office of Personnel Management, OPM, mandatory requirements and duties of review to ensure the agency's decision was lawful. Case was completely developed without proper documentation and closed, and ensuring the employee's rights are protected. The documentation attached clearly indicates the administrative process was improper. Plaintiff's rights was not protected. The system failed to EEOC docket number 0120161493 provide fair and equal treatment under the color of law. Plaintiff believes this was a collective effort by USPS managers, from duty station at 3301 Wrightsboro Road, Augusta, GA, to district headquarters in Macon, GA, including admin managers, such as human resources, labor relations, personnel, legal departments, and U.S. Department Office of Personnel Management. Failure to discovery errors or failure to take corrective action during case review of a personnel action of termination, imposing punitive discipline as a retaliation for plaintiff exercising a right to an entitlement granted and protected by a constitutional law, known as the Family Medical Leave Act, FMLA. Managers at all levels are required to be knowledgeable of the FMLA law. Plaintiff loss of income created a financial hardship, was very depressing, troubling, and later became totally disappointing. After discovering the factual evidence supporting the alleged misconduct of federal employees, managers, who are entrusted with supervisory and decision-making authority over other federal employees, with oath of office responsibilities, bond to sworn duties and entrusted to perform their duties fairly, equally, with a genuine care and concern for the welfare of all subordinates, without discrimination. The findings revealed that some members of management are dishonest, untrustworthy, lacks integrity, displays poor character behavior, performing duties unprofessionally, management skills, immoral values, and could be easily influenced to violate sworn duties and oath of office willingly, without any fear of discovery or retaliation for misconduct. This also was emotionally depressing, degrading and disgraceful to plaintiff's years of honorable military service defending and protecting the Americans' way of life. Worst of all, plaintiff confidence in the government became questionable, and shocking beyond belief of this level of evilness. 1. The misconduct prohibited rights to due process of law as follows. 2. Violations of constitutional laws. I. The constitutional guarantee of due process of law, found in the 5th and 14th Amendments to the U.S. Constitution, prohibits all levels of government from arbitrarily or unfairly depriving individuals of their basic constitutional rights to life, liberty, and property. The Due Process Clause of the 5th Amendment, ratified in 1791, asserts that no person shall be deprived of life, liberty, or property, without due process of law. This amendment restricts the powers of the federal government and applies only to actions by it. The Due Process Clause of the 14th Amendment, ratified in 1868, declares, "Nor shall any state deprive any person of life, liberty, or property, without due process of law." Section 1. This clause limits the powers of the states, rather than those of the federal government to 1. The Due Process Clause guarantees and protects rights to appeal a personnel action final decision made by a federal agency. Schemes were taken to prohibited appeals of review and complaint. B. The USPS processed an adverse decision of removal of the USPS Dispute Resolution Team (DRT) as final. I. The DRT decision's effective date was September 13, 2008, 115 days before the date of enactment, and the notice of decision was received February 7, 2008, 40 days after enactment. The backdating the effective date and delaying the notice of decision are unlawful, intentional, deceptive and prohibited personnel practice. 2. The effective date of personnel action of removal 1. Cannot be a retroactive effective date. A retroactive effective dates only apply to back pay. B. The effective date must be the date of enactment or later. C. The date of enactment was December 29, 2008. The DRT effective date was inconsistent with the terms of the agreement and unlawful by Title V, USC. I was on USPS roll, in a no-pay status. I received a pay stub dated March 6, 2009. 2. The DRT effective date was intentional. They are trained to resolve disputes. It is stated in the labor agreement that an employee is to remain on the roll until all appeals exhausted. 2. USPS rep and NALC rep knew the DRT decision of removal was not the final step, and both knew the next step was to send the grievance to arbitration as directed in the agreement. Both reps were responsible for sending the grievance to arbitration and ensuring the process was fair and proper. 3. NALC reps were bound by oath of office to protect the interest of the employees. This did not happen. The DRT effective date was deceptive. 1. I believe that retroactive effective date was a scheme used to make the effective date appear legal and lawful, but it is unlawful. 3. 2. I believe that was a scheme to cause dismissal of appeals or complaints, as filed untimely. The DRT's decision of removal document, on page 3 of 3, states, "Therefore this grievance is denied in its entirety." I believe this was a gimmick to make the decision appear final and to make plaintiff believe it was not appealable. This statement is unlawful, deceptive and criminal. 3. Intentional misconduct using gimmick schemes and deceptive methods to obstruct the constitutional rights of an employee is a criminal act. V. Substantially prohibited rights. 1. Notice violations. No notice was sent to. The notice of decision should have been received within 5 days after the date of enactment to allow me the opportunity of appeal. Both USPS and NALC were responsible for overseeing and ensuring that the procedures are fair and truthful, but they did not. V. Effects of notice of decision not being sent was intentional. 1. To avoid reviews and to process the removal decision of USPS Dispute Resolution Team, which had no final decision authority of an adverse personnel action, but did so anyway. When I received the decision removal 40 days after the enactment date, my termination was administratively completely processed, finalized, and I was removed from the roll of USPS without due process. 2. Notice of decision delay. Prohibited rights of appeal made all appeals and complaints appear untimely. 3. Intentional. USPS had no intention of allowing me the opportunity to appeal the removal decision. Evidence of this fact is documented on page 3 of the removal decision of USPS Dispute Resolution Team letter, which states, "The grievance was denied." Also violates the following ADA ruling. B. 226. HR Rep number 558. 101st Cong. 2D Sess. Part 3. At 85. 1990. It is the intent of the conferees that the use of these alternative dispute resolution procedures is completely voluntary. Under no condition would an arbitration clause in a collective bargaining agreement or employment contract prevents an individual from pursuing their rights under the ADA. C. This provision of law applies to my case. I am a veteran with service-connected disabilities. USPS is aware of my disabilities documented on the attached USPS Personnel Action Form. D. The charge of AWOL for using requested sick leave is prohibited by law and is a protected right to an entitlement granted by constitutional law known as the Family Medical Leave Act. See Prohibited Personnel Practices. Corruption. 1. The only way the unlawful altered method could be enacted and achieved was first to influence NALC reps to agree with the decision and breached the union agreement. as well as violating duties of office as an elected NALC reps. My NALC reps did not ensure the process of the grievance procedures conformed with agreement. B. Did not question the imposed punitive discipline justified as just cause action of removal. 5. I. Abuse of discretion. 1. 2. Excessive no documentation of prior discipline was used to support the decision of removal. C. Breach of contract. I. The charge justifies as corrective discipline. The level of discipline action is based on prior discipline of the same type. 1. In this case there is no prior discipline of AWOL oral or written. 2. Discipline, if any, should have been no more than a letter of warning. 3. The dispute resolution team did not inspect or verify the case documentation was complete and proper to support a decision of removal. 4. The processing time of completion had passed the 60-day time frame when the case was received by DRT on December 19, 2008, and was not contested by NALC reps. The total time was 115 days, decided on December 29, 2008, with an effective date of September 13, 2008. 2. Based on the documented evidence attached, legal review procedures, duties and checklist of the agency's administrative processing departments relating to personnel actions, did not review and/or process my case as required, due to numerous errors in the case documentation. This fact alone is suspicious and is more likely than not a member of upper management influenced, approved and/or directed the acts of misconduct in this case. The altered methods and other unlawful conduct are believed to be the creation of a person who has knowledge of a discipline procedures, b. appeal procedures, c. training, experience and may have used these altered methods in the past. D. Authority as a member of management with influence. E. Knowledge of reviewing authority policies and procedures. 6. F. Friends and contacts in other departments and agencies. G. A buddy-buddy system to overlook, hide, and/or cover up any misconduct of the agency. H. Confident and felt comfortable that the created methods would not be discovered and if an employee appeals, it would be dismissed as untimely. I. The above list of facts are circumstantial evidence that a person needed to develop schemes, gimmicks, find loopholes, write policies and procedures for acts of intentional misconduct by knowing the ins and outs of the system such as the filing timeframe of appeals. I. Being aware of applicable authority review processes of an action and how to create a problem for dismissal, such as untimely filing of appeals. J. By delaying notification of an appealable decision. 1. Inserting loopholes and/or conflicting procedures such as in this case, using a retroactive effective date. 2. Allegations of USPS upper management were knowledgeable of corruption at district headquarters level and throughout USPS. 1. Violated duties and responsibilities for overseeing and ensuring the process is fair, lawful, and the employee's rights are protected. That did not happen. Processed the formal Step B decision of removal without completing the grievance arbitration review of the case procedural steps and proper documentation obtained to support and required for a removal decision. B. Every action below the district level that is processed through departments at the district headquarters has to be reviewed and approved by the department manager before processing. C. Someone with influence, temerity and upper management level of authority influenced department managers to process the case without the proper documentation to support the decision of removal. I. 7. Believe the person was James Sizemore, Postmaster, Augusta, Georgia. 3. Misconduct of USPS management is known throughout the agency and NALC. A former NALC national president, William H. Young, was aware of USPS managers' misconduct and informed all union members by inserting and signing a statement in the NALC Bulletin No. 0903, dated February 12, 2009. Subject: Statement of President William H. Young on compliance with national agreement. 1. The following is a paste copy of the statement. Let me make the following clear to one and all, including Postal Service management at headquarters and in the field, and all letter carriers, at every level in the union and in every post office. No one, at any level, has any authority to amend or violate the national contract. Period. I continue to receive calls from branch officers who inform me that local managers have approached them and attempted to secure agreements to violate the national contract. These same managers have the audacity to suggest that I am cooperating with the Postal Service and that they should. 2. The plain fact is that I encourage cooperation with the Postal Service because I realize the current financial crisis requires cooperation, where appropriate, If any manager approaches you with a suggestion for creative cooperation, advise them to send their ideas to USPS headquarters, which will then make the determination whether to present such ideas to us. Some of the ideas floating around now are not grounded in common sense. For example, the idea of prohibiting all carriers from working their non-scheduled day off, and then requiring non-ODL carriers to work overtime is a clear violation of the contract, one we will stop through the grievance procedure, and one that will cost the USPS dearly in the end. We must be mindful of the critical difference between contract amendment, contract violation on the one hand, and creative, positive cooperation on the other. Another use of the altered method was to avoid review and prevent the case from being sent outside the district's control and authority. On 8. Appeal to a neutral third-party arbitrator as required by agreement and law. 1. Evidence. The two different effective dates of removal. The DRT date is September 13, 2008. 2. The USPS Personnel and Finance Office dates are December 29, 2008. 2. Another reasoned decision of removal by the DRT was unlawful and USPS knew so, is the attached document M01648. Subject: Memorandum of Understanding between the United States Postal Service and the National Association of Letter Carriers, AFL-CIO regarding Article 15 Dispute Resolution Process, is a document of the dispute resolution team staffing, training, certifications, duties, and responsibilities. Highlighted on this form is a list of breaches of the agreement. No third-party mediator present. Decision cannot be final. 2. 3. Grievant was not allowed at the meeting. Extended processing time of completion. B. Did not ensure proper documentation was present for a fair evaluation on the merits. No ex parte communication is required in writing for removals. 1. I did not receive a 30-day notification of the Step B decision, nor was my case sent to binding arbitration as required by the agreement. 2. Step B had no final decision authority in removal cases. A. Obstruction of justice applies to B. Intentional misconduct. C. Allegations of unlawful acts. D. Creative schemes and gimmicks. E. Due process of law. D. Estoppels and equitable tolling. Due to the misconduct of a federal agency, this provision of law applies to this complaint too. Waiver and exception to statute of limitations. 9. 3. 29 CFR Section 1614.604 Filing and computation of time. All time periods in this part that are stated in terms of days are calendar days unless otherwise stated. B. A document shall be deemed timely if it is delivered in person or postmarked before the expiration of the applicable filing period, or, in the absence of a legible postmark, if it is received by mail within 5 days of the expiration of the applicable filing period. C. The time limits in this part are subject to waiver, estoppels and equitable tolling. D. The first day counted shall be the day after the event from which the time period begins to run, and the last day of the period shall be included, unless it falls on a Saturday, Sunday or federal holiday, in which case the period shall be extended to include the next business day. Equitable tolling is a legal principle evolved from the common law of equity. Equitable tolling states that the statute of limitations will not bar a claim if the plaintiff, despite reasonable care and diligent efforts, did not discover the injury until after the limitations period had expired. 1. Several acts of misconduct as stated above obstructed my opportunity of timely filing appeals and complaints. 2. Review rights by law. The 5th and 14th Amendments to the United States Constitution each contain a due process clause. Due process deals with the administration of justice, and thus the Due Process Clause acts as a safeguard from arbitrary denial of life, liberty, or property by the government outside the sanction of law. 1. The Supreme Court of the United States interprets the clauses more broadly because these clauses provide for protections, procedural due process, in civil and criminal proceedings, substantive due process, a prohibition against vague laws, and as the vehicle for the incorporation of the Bill of Rights. Due process ensures the rights and equality of all citizens. B. See reference. Supreme Court of the United States Syllabus Elgin et al. V. Department of the Treasury et.al. Certiorari to the United States Court of Appeals for the First Circuit No. 11-45. Argued February 27, 2012. Decided June 11, 2012. Most allegations of misconduct listed in this complaint are facts, supported by documented evidence. Some are factually true, as circumstantial evidence, supporting the theory of law more likely than not true. The use of altered methods and procedural violations. 10 makes it very clear of intentional wrongdoing. The allegations intentional misconduct of federal employees, especially federal employees with management authority of regulation, administration, superintendence, care, charge, conduct, guidance, treatment, apply to the provisions of law indicated in this complaint, plus additional provisions of law including but not limited to agency's policies, FMLA, Titles 18, 5, 29, 39, 42, ADA, Ethics Act, and other applications of law. Special attention should be focused on managers' involvement by job titles and levels of authority. Relief requested in this case is reinstatement, back pay, average overtime hours pay and compensation of punitive damage. Should include an additional compensation award, determined by the merits of complaint, which indicates numerous acts of unlawful misconduct and law violations of more than one federal department and agency. Request compensation for punitive damages of no less than $5 million. The amount of the award should be the maximum amount authorized by law. Continuous misconduct and enough to get their attention. Stop prohibited employment and personnel behavioral practices. With written notification to practice preventive measure and misconduct will not be tolerated. USPS has a long history of misconduct decisions, judgments and rulings from Complaints Section 1614.501 Remedies and Relief. When an agency, or the Commission, in an individual case of discrimination, finds that an applicant or an employee has been discriminated against, the agency shall provide full relief which shall include the following elements in appropriate circumstances. 1. Notification to all employees of the agency in the affected facility of their right to be free of unlawful discrimination and assurance that the particular types of discrimination found will not recur. 2. Commitment that corrective, curative or preventive action will be taken, or measures adopted, to ensure that violations of the law similar to those found will not recur. 3. An unconditional offer to each identified victim of discrimination of placement in the position the person would have occupied but for the discrimination suffered by that person, or a substantially equivalent position. 4. Payment to each identified victim of discrimination on a make-whole basis for any loss of earnings the person may have suffered as a result of the discrimination. And 5. Commitment that the agency shall cease from engaging in the specific unlawful employment practice found in the case. 11. Conclusion. The facts and merits in this case justifies the criteria standards for investigation and relief set by law. Plaintiff's biggest mistakes were having confidence in the agency's integrity, a belief that managers and union representatives could be trusted, no knowledge of USPS past history of misconduct and was not informed or knowledgeable of the discipline processes and other applicable provisions of law. Plaintiff discovered during research of Title IX, arbitration. Based on the facts of this case, USPS decision of termination is invalid, unenforceable, and unlawful, meaning the decision is void, based on a provision of Title IX, arbitration, which protect the rights of employees from any employer misconduct. Plaintiff is actively on the roll and still a postal employee. 1. If a person is not allowed to participate or intervene in the processing, the person is not bound by the judgment or decision given in the case. A plaintiff was an indispensable party. A person whose interest is sure to be affected by the outcome of is considered an indispensable party, and the case cannot proceed without this person's participation in the processing. 2. The only appeal plaintiff filed that processed and investigated, including an in-person hearing, was conducted by Georgia Department of Labor, DOL. Georgia DOL ruled USPS decision of removal was unjustified. Copy attached. The provisions of authority below applies. A subpart G. Effect of other laws, employer practices, and collective bargaining agreements on employee rights under FMLA. Section 825.700 Interaction with employers' policies. B subpart G. Effect of other laws, employer practices, and collective bargaining agreements on employee rights under FMLA. Section 825.700 Interaction with employers' policies. See Section 825.220 Protection for employees who request leave or otherwise assert FMLA rights. The FMLA prohibits interference with an employee's rights under the law, and with legal proceedings or inquiries relating to an employee's rights. This discrimination complaint is within the jurisdiction, justification of EEOC authority of review, investigate and enforce the applicable laws pertaining to this complaint. If any additional information or clarification of anything related to this complaint, Please call BEST or email plaintiff at cell phone 706-597-6445, updated number, or email petershanks747 at gmail.com. Thanks Peter Shanks 12, 13.